So, hello everyone and welcome back to Equity Podcast, where we're diving into the fascinating topic of injunction within the legal framework. As injunction are critical remedies in equity, we often use to prevent irreparable harm or maintain the status quo in legal dispute. So today we'll focus on understanding their nature, the distinction and similarities, and as well as the judicial analysis of relevant cases from Asia and beyond. So joining me today, first is Mr. GURMEET SINGH, who will guide us through the nature of interim and interlocutory injunction. Mr. Adam, who will break down the differences between two types of injunction. Ms. Ashwinie, where we will explore the similarities, and lastly, last but not least, Mr. HAFIZAN, who will analyse judicial cases, including recent development from Malaysia, Singapore, Australia, and New Zealand. So now let's get started by laying the groundwork within the legal framework of injunction. Injunctions are deeply rooted in both substantive and procedural law, ensuring that equitable principles align with legal fairness. So let's look at the mentioned context, which draws on key legislative provision. So the Specific Relief Act 1950 forms the backbone of substantive guideline, particularly Section 4 Parac, Section 50 to Section 55, which details when injunction may be granted or refused. Procedurally, Order 29 of the Rule of Court 2012 outline how to apply for injunction, emphasizing urgency, irreparable harm, and the inadequacy of damages as a remedy. Courts also consider the balance of convenience and whether there is a bona fide question to be tried. And lastly, the Court of Judicature Act 1964 reinforced the inherent equitable jurisdiction of Malaysian courts, allowing flexibility to address unique circumstances. So, to better understand this framework, let's compare Malaysia with the United Kingdom, which heavily influenced Malaysian equity law due to its colonial legacy. So, both jurisdictions emphasize equitable principles like fairness and judicial discretion. Notable cases such as American Cinnamon Crow and Mariva Compania Nevera SA have shaped principles for interlocutory and Mariva injunction. Malaysia has adapted these cases as seen in Kit Gerald Francis Noel John cases and Zainal Abidin Haji Abdul Rahman cases, tailoring them to its legal and societal context. So, Mr. GURMEET, over to you. Can you walk us through these two types of injunction that you will talk about, and how they function within the legal framework?
Well, we are talking about nature of interim and interlocutory injunctions. As we know, all injunctions are governed under the Specific Relief Act 1950. That is in the context of Malaysian scenario. Now, injunctions are a very important part in any civil litigation, especially, we have two major injunctions here. We're talking about interim injunctions as well as interlocutory injunctions. Now, sometimes, you see, there are two types of these injunctions. We have prohibitory and also mandatory injunctions. And injunctions application in court normally is inter partes. That means both the claimant and defendant will be notified and they will be in the courts. But sometimes an ex parte injunction can be filed. Ex parte here means that the defendant will not be given any notice about the impending application for any injunction. This happens in very urgent cases. I'll give you a good example. Like if I have a house where it's 300 years old, and it has been given accorded an heritage status by the authorities, and on the land adjacent to my house, there's some piling work just begun. The moment the one or two piles have been driven, I find my wall is already cracking. Now, I have to rush to the court ex parte without informing the party. Now look, this kind of damage, if my house comes crumbling down, no amount of damages awarded by court can be adequate damages will be awarded to me. Nothing can, it's sentimental value, it's also heritage value. House comes out, you cannot give me the same house, right? So it's court in that conditions, court will look at the urgency of the matter and grant an injunction to stop the piling work, you see, because no amount of damages can be adequately given to me to compensate me adequately for the house which I lose. So this is based to give you a glimpse of what an injunction is. So injunctions, again, I would reiterate, that's a very important part in civil litigation, and it must be there in place. Court will look into a few factors, whether if they don't grant an injunction, how much damage will it cause to the claimant. That's one important. The urgency matter is another important thing which the courts will consider, and this is about injunctions.
Okay, thank you, Mr. GURMEET, for that insightful explanation. So next we have Mr. Adam. Now, we've understand the nature. Could you highlight the key differences between interim and interlocutory injunction?
Okay, so let's talk about difference between interim and interlocutory injunctions. So these two common types of interim and interlocutory injunctions serve different purposes and are used as instinct stage of litigation. Interim injunctions are sought at the very start of the case, often in urgent situations where immediate action is necessary to prevent irreparable harm or disruption. They are typically granted without notifying the other party because of the pressing need to act quickly. But interlocutory injunctions are sought later, after the initial stage of the case but before a final decision is made. These are granted after hearings where both parties present their arguments and aim to provide temporary relief while the court resolves the main issues of the dispute. The procedure also, these two injunctions have difference. And for the interim injunctions, often rely on minimal evidence such as affidavits due to their urgent nature and are decided in ex parte hearings. For interlocutory injunctions, require substantial evidence, including detailed documents or expert reports, and are decided after inter partes hearings, where both parties present their cases. Judicial research is lighter for interim injunctions, focusing on immediate needs. For interlocutory injunctions, the research is strict, considering persuasive evidence and the broader implications of granting relief. In summary, interim injunctions address urgent short-term needs, while interlocutory injunctions provide longer-term relief pending case resolution. Understanding the difference help practitioners and litigants effectively protect their interests during legal proceedings. Thank you.
Thank you, Mr. Adam. Go to Ms. Ashwinie. Now that we have discussed the differences, could you shed some light on the similarities between these two types of injunctions?
Sure. Let's start with the equitable nature. Both interim and interlocutory injunctions are based on fairness. So they are not automatically granted. Instead, courts carefully consider each case to decide if issuing an injunction would be fair and necessary. For example, the Senior Court Act 1981, Section 37 Clause 1 allows courts to issue injunction when it is just and convenient. So this shows that courts focus on maintaining fairness while resolving disputes. Next, let's talk about the balance of convenience. When deciding whether to grant an injunction, courts weigh the potential harm to both parties. The goal is to ensure that the person likely to suffer the most harm is protected. This principle was famously explained in the case American Cinemite Co. and Ethicon. The court said it's especially important to weigh this balance when money isn't enough to fix the problem. Legal expert Zuckerman also points out that this rule prevents injunctions from causing unnecessary harm to either side. And lastly, there is this idea called irreparable harm. To get an injunction, you have to show that the harm you might suffer can't be fixed with money or any other remedies. Legal scholar Sharp highlights in his book that irreparable harm is a key factor in granting injunction. It ensures that injunctions are only used when absolutely necessary. The Canadian Bar Review adds that court needs clear proof of this harm before acting. So basically, that is all for the similarities between interim and interlocutory injunction.
Thank you, Ms. Ashwinie. So, for tying those concepts together, next, our last panel, Mr. Hafizan, will analyse the relevant judicial cases and recent development information in Singapore as well as New Zealand. So, Hafizan, take it away.
Thank you, Mr. Moderator, for inviting us. Okay. So, what is the cases that is notable, or I can call it as famous for this type of topic? So we have to look at the recent cases which has happened last year, 2024. MOHAMMAD versus Artem Musienko. So MOHAMMAD is a product comparison services company. The company that has the product comparison services, and Musienko is former employee of the MOHAMMAD company. So during Musienko's employment in MOHAMMAD, okay, they have two employment contracts, which is the compete clause and confidentiality clause. Okay, the compete clause basically prohibit him from working at competitors in Southeast Asia for a certain period of time, while confidentiality clause explains that this clause is restraining him from using confidential information that he gained or the knowledge that he was teach during his employment in MOHAMMAD company. Okay, so the time has passed and Musienko left the job at MOHAMMAD company, and then he got a position as the head of engineer at CAGRS, which is one of the competitors of MOHAMMAD company. So the MOHAMMAD thinks that Musienko has breached the contract. So the MOHAMMAD company seeks the interim injunction to prevent him working at a CATRS company. Okay. However, the court found that the compete clause was invalid, which is management depends on both of the clause. Okay, the court found that the compete clause was invalid because the information and the rules that was stated in the compete clause was already stated in the confidentiality clause, and also the court has applied the strategic principle, which I can summarize it as the money smart company cannot prove that they are confidential enough to restrain Musenko from keeping the information, and also management could not prove that the management company has trained Musenko for a certain period of time to make the information confidential or make it secret. Okay, so the court held that there's no breach of contract. Okay, simply because the information that Musenko gained, the knowledge that he had learned during his employment in management company, is already public knowledge. So the management company cannot rely on these both cases to seek interim injunctions. So in conclusion, the management against Arthur Musenko underscores the delicate balance actually between protecting business interests and preserving employee mobility. Okay, with that, that's all from me. Thank you.
Okay, thank you, Mr. HAFIZAN, for that thorough analysis. Now, as we come to the end of our discussion, let's recap what have we learned today. So, to sum it all up, we have explored the legal framework, including statutory and procedural guidelines, and compared Malaysian practices with those in the UK. In the distinction and the semantics between interim and interlocutory injunction, as well as insight from judicial cases, illustrate how court ensures equity and fairness. So, I'd like to thank all of our panelists for their valuable contribution, and to all of our listeners, thank you for tuning in, and see you again next week at Monday 7 PM. Yeah. Bye.